Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense. Should you have your lawyer look over that contract? I'll have an answer for you in just a second. I get calls all the time from folks who want to ask me a simple question. They'll say something like, my contract requires me to work 20 hours a week, but I've been working 25 hours a week. What should I do? And my answer to that routinely is, well, I don't know because I don't have your contract in front of me. One of the most important services a lawyer can provide to you before you sign a contract is to review it and help you see where the minefields are. Now, most people do not read a contract all the way through. They look for the things that make sense to them. Okay, the contract says I have to work 40 hours a week. Yeah, got that. Contract says I'm going to make $17.50 an hour. Okay, got that. The contract says I can work a maximum of 60 hours a week. I got that. And that's it. Those are the things they look at. Otherwise, it looks good to them. They sign the contract and they miss some of the most important parts of a contract. What are those? Well, first of all, for hundreds of years since the founding, even before the founding, when someone had a problem with a contract issue, they went to court and they had a neutral judge decide whether or not the contract was valid and decide whether they had to pay money or whether they should be paid money. But since the Federal Arbitration Act was passed in the 1930s, more and more contracts are being sent through arbitration. What is arbitration? Well, arbitration is private dispute resolution. If you sign a contract with, for example, AT&T for your cellular service, you'll sign an arbitration agreement in that contract. And that arbitration agreement requires you to submit the matter to arbitration. And arbitration is essentially where AT&T gets to pick one arbitrator, you get to pick one arbitrator, and those two people, the person you picked and the person that AT&T picked, pick a third arbitrator. The reason you have to have an odd number is because you need a majority decision. Now, when you go through the court system, you have an opportunity to influence who's in the court system. In most states, you have an opportunity to vote for judges. And as a result of that, you have an opportunity to craft the people who will be deciding your case. They are at the very least responsive to you at some point through the electoral system. Not so with arbitrators. Arbitrators tend to be appointed or selected by the entities that are running arbitration. One of those is the American Arbitration Association. It's a good group of people. They have their own rules, and the rules are very similar to the court rules in most states. The process is, assuming that it is followed rigorously, about as fair as you would get in a court of law. So if you don't have a lawyer look over your contract, you might not recognize that you are giving up the right to sue if you have a problem as a result of that contract. In addition to that, lawyers tend to be really good science fiction writers. And I say that because a science fiction writer has to imagine alternative possible universes. And essentially, when you're reviewing a contract, you have to think about the things that could go wrong. For example, what do these words mean? What does this phrasing mean? I'll give you a really good example from a case that I handled. I handled a case called Burns versus Smith where the insurance agreement said that a business was the operation of a business and the use of the premises to operate that business. In that case, the injury occurred off of the premises. And as a result, we argued that the exclusionary clause, which said it had to be a business and operated out of the facilities that were insured, did not apply. The insurance company argued that and really meant or, that if you held the paper up just right and tilted the light, that you could figure out that it really meant or and not and. And the Missouri Supreme Court said, nah, you used and. I kind of think you meant and. So that's the kind of thing that a good lawyer can do for you. He can spot mistakes like that in a contract. Now, you're probably wondering, for heaven's sakes, don't insurance companies have battalions of lawyers? Yes, they have battalions of lawyers, no question. But that doesn't mean they read every single sentence either. And it is the sentence that they don't read and don't think about that usually comes back to bite them. The same thing can be said about a very simple contract between you and your neighbor. You agree to buy your neighbor's lawnmower and he agrees to sell it to you, but that is not all. What happens when that lawnmower throws a rock and hits a kid? Who's liable for it? The person who bought the lawnmower and didn't fix the defect in the discharge chute, or you because you didn't recognize the defect in the discharge chute? You see, thinking about how problems occur and what kinds of problems have occurred in the past, a lawyer with a couple of years' experience is going to be much better at telling you where you might have problems later on. So, when you think about whether or not to just read the contract and sign it, the answer is never just read the contract and sign it. The answer is to read the contract, put it away for an hour, then read it again. Then take it to your attorney, ask him to read it, and get his legal opinion. Yeah, you're probably going to pay $100, maybe $200 to get his opinion. But if it saves you $10,000 down the line, or maybe more down the line, that will have been money well spent. In nearly any enterprise where you are going to be heavily invested, you need to have a lawyer look over your contract before you sign it. Now, as a lawyer, usually when I get a contract, it's after somebody signed it and after there's a problem that has arisen. And now I'm stuck with the wording of that contract. I don't get to say, well, what it really means is this. And more importantly, if the language of the contract is clear, what's called the parole evidence rule will keep you from being able to say to a judge, but, when we talked about it, Billy Bob said that this meant thus and so. That doesn't happen. The words of the contract control the four corners, and if it's not ambiguous, then other evidence isn't admissible to vary or distinguish what's in those words and what's on that page. So, my advice, always get a lawyer to look over things that are important. If you have any questions about this, please leave them in the comments down below. And if you haven't already, please go over here and subscribe to our channel. Naturally, I'd appreciate it if you would give me a thumbs up and share this video with anybody you think may benefit from it. Thank you so much for watching. Have a terrific day.